Ladies and gentlemen, good afternoon. We had a very long day, so I hope that in this session, in addition to learning, we'll also have reason to smile from time to time, because according to the instructions that we received, the speeches are supposed to be flowing and not too heavy, and without PowerPoints. And so we'll try to do it in a good spirit, even though the subject quite concerning and worrisome in some countries. And so I would like to open this session, but just want to make sure that the panelists are here. I know Justice Nussberger sent us a video, and we will add it to the recording of this session. Professor Pichonnaz on my right, no relation.
No relation.
On my right, the president of the ELI. On my left is Dr. Sophie Turenne. And I want to recognize and to make sure that other members are here. Is President Mohammed Abdenabaoui here? No. I know that Justice Ribeiro is here. Welcome. Justice Carmen Corral is here. Welcome. And then we have Professor Giuseppe Ferrari is here. And Professor Sophia Tang is here too. So I'm glad that all of you give us the great honor of listening to you later. I will open with a few notes and comments. First of all, I would like to begin with the notes of thanks. Many thanks are due to Javier Remades, the president of the World Jurist Association, to the leaders of the New York Bar and the American Bar Association, whom we heard today, to Ms. Teodora Toma, who helped us organize this session, Ms. Yaki Rodriguez, Diego Solana, and we're grateful to Irene Esteban, who was helping us in the organization of this session. Special thanks are due to the European Law Institute that coordinated this session together with the World Law Congress. The European Law Institute, whose president, Professor Pichonnaz, sitting next to me, is one of our speakers today. The ELI initiated a project of, together with the International Association of Judicial Independence, which I chair, to develop standards of judicial independence for the European countries. And I would like also to thank all the distinguished speakers of this important panel that we will hear in the course of this evening. And of course, I would like to thank all of you who come to listen to whatever things we have to say. I hope they will be useful and will stimulate some thinking on this subject. Judicial independence faces great contemporary challenge in many countries with diverse legal traditions and diverse legal cultures. The challenge is presented by changes in the system of government and changes in political ideology. The changes have taken place after elections or after change in the system of regime, as happened in Eastern European countries, with the lifting of the Iron Curtain and the transition from a communist regime to a dramatic democratic regime. We noticed changes in countries that are very frequently referred to, like Poland, Hungary, Turkey. Unfortunately, the change is emerging in Israel, my country, not yet introduced, but we don't know what will happen. The powers of the civil society and the democratic supporters are trying to stop it, but we don't know. We'll have to wait. The congestion and delays and the limited resources of the courts create pressure on the effort to uphold the traditional basic values that underlie the justice system. These challenges for the courts also arise from technological developments that enters the legal world, such as the use of online procedures, AI in the courts, as well as remote trials. In this context, we must pay attention to a selected number of issues related to judicial independence and due process of law. We should pay attention to the foundations of the due process of law and the requirements of fairness, independence, and impartiality of the judicial process. These foundations and requirements are secured in domestic provisions, such as in, let's say, Article 3 of the US Constitution, 5th Amendment, 14th Amendment of the US Constitution, in international treaties like Article 6 of the European Convention on Human Rights, Article 19 of the EU Treaty, and the decisions of both the domestic and the transnational tribunals. Justice Ribeiro of Portugal, and who is a vice president of the Constitutional Court, will discuss the Portuguese judge's case in the course of this evening. Professor Giuseppe Ferrari from Italy will analyze cases from Italy and other jurisdictions. The European Law Institute embarked upon, as I mentioned, a project with the International Association of Judicial Independence in World Peace to develop the ELI Mount Scopus European Standards of Judicial Independence. Professor Pascal Pichonnaz will give us a report about some aspects of the activities, the ELI in general, and particularly this particular project. Professor Sophie Turenne from Cambridge will give an analysis of the main themes of the standards that are developed by this group. The basic values of the justice system, which I mentioned, we have to recognize that there are those values, but they are challenged by changes, mostly by reforms that are efficiency-oriented, which create tension between the conflicting values of the justice system. My view is that basic values of the justice system are judicial independence, fairness, impartiality, access to justice, efficiency, accountability, and public confidence in the courts, and protection of the justice system and judicial process at the constitutional level rather than at the legislative, lower normative level. Now, among the basic values of the justice system, judicial independence deserves special attention, which is the subject of our session this evening. Judicial independence is a cornerstone of democracy and is essential for the rule of law and for maintaining the due process of the citizens. Actually, my 6th book on the series of judicial independence is entitled Judicial Independence, Cornerstone of Democracy. Professor Turenne has an article, Professor Ferrari has an article, and Professor Diego Chayan of Peru, who received a medal this morning, has 2 articles in the book. So it is quite an honor to have all these contributors in this book on judicial independence, cornerstone of democracy. Judicial independence is also an essential foundation for ensuring economic growth, international trade, and it was also important as a recognition of domestic judicial decisions and awards in foreign countries. When such a decision is brought for enforcement in third countries, if there is no independence or integrity, there are problems of enforcing these decisions. Judicial independence has many aspects: the independence of the individual judge, the independence of the judiciary as a whole, the institutional independence and the internal independence of the judge vis-a-vis his fellow judges. The individual independence comprises of personal independence, including his security of tenure and irremovability, and of substantive independence in the exercise of his judicial function, his or her judicial function. We expect judges to exercise their function to defend the rule of law, including the independence of the judiciary and the independence of the courts. We expect them to do so in normal times, and especially we expect them to do it in crisis times. Various aspects of the independence will be presented by the speakers in our session. Professor Angelika Nussberger was supposed to be here, but she apologized and sent a video, but the video technically is not practical to be shown to you now. We will send it, we'll put it on the internet. Her speech is about the Venice Commission and the views of the Venice Commission regarding judicial independence.
Dear colleagues, I'm a bit sad that I cannot be with you now in New York. I would love to be with you, but I'm happy that nevertheless I can record a video and thus address you. The topic you are discussing about judicial independence is, I think, now more important than ever. We have been elaborating standards both on the regional level and on the universal level. Nevertheless, the situation is obviously deteriorating, especially in the last years. At least it seems to me you will see during your discussion what you think about it. We all come from different regions of the world, but it seems to me that we face similar challenges. I want to speak from the European perspective. I have been a judge and vice president of the European Court of Human Rights. I am right now vice president of the Venice Commission, and I'm also a judge at the Bosnian Constitutional Court. So I have 3 different judicial perspectives, or different perspectives on the judiciary, being part of an international judiciary, being part of a national constitutional judiciary in a country which is in a very difficult, complex situation, and also being member of a body that is called upon to set standards, to define standards for Europe and beyond. So this is the experience on which I build and which I want to share in those few minutes which my video will last. I want to start with the observation that it seems to me that in the last years, the judicial cases on judicial independence have exploded. So the judiciary itself is sort of reflecting on the basis of the cases about standards on judicial independence. I know a very early case on judicial independence decided by the European Court of Human Rights, Softrans-Afto versus Ukraine, which was, we cannot say otherwise, a scandalous case. There was a letter of the president of the country, the president of Ukraine, was found in the file advising the president of the court how to decide. So this was a shock to see such a case. That was a case in the early 2000s. But then we had not so many cases for quite some time. And then we had another, actually once more a case from Ukraine, another important case, which was Volkov versus Ukraine, where the court was confronted with a situation where a judge had been dismissed from the Supreme Court, obviously because of political reasons. The dismissal was based on a disciplinary procedure, and this disciplinary procedure was not adequate, and those who took part were biased. Nevertheless, there was no real control of what was happening. This was the case where the European Court of Human Rights had for the first time a real possibility of developing standards, especially on judicial councils. Judicial councils are a very important feature when we discuss judicial independence. They were, I think, more or less common in Southern European common, whereas they were not so common in Western European countries, like my own country, Germany. We never had this system. And they were designed to be a good model for the new democracies in Central and Eastern Europe. But as we can observe during the years, these judicial councils created a lot of problems. It was already the question how they should be composed, who should be there. There are two extremes. One is to have only judges, but then it's isolated and sort of cut off from the rest of society. Whereas whenever you integrate others, politicians, for example, the danger of bias or political decision-making is very big. So we have seen in many systems that these judicial councils did not function as they should. And so the Venice Commission has advised those countries which have a stable judicial system that it's not absolutely necessary to change it and to adopt this model of judicial councils. But for those in the new democracies, it still might be the best one. But then there are special standards on the composition of these judicial councils. Right now, for example, in Ukraine, we see that a new judicial council is built up with the participation of foreigners in order to have a new start for judicial independence in Ukraine, where we had major problems. I said the case of Volkov was one of the first basic and important cases by the European Court of Human Rights, and now we have arrived at such an important case like Gudmundur Astrid Andretsson versus Iceland, which is probably known to all of you because it shows that all applicants can challenge the composition of a court whenever the procedure for the selection of judges was not fair and adequate. So this was a big step, and it was a big step especially for the supervision or for the dialogue with countries like Poland and Hungary, where we had all those problems with judicial independence. I just want to mention, perhaps as an input for your further discussion, three aspects in this context. One is political influence on judicial independence, and there I want to give you my Bosnian example, where the fact that politicians in Bosnia never find any compromise has now spilled over to the Bosnian Constitutional Court, and the Republika Srpska, so one entity of Bosnia, has asked its only remaining judge to step down from the Constitutional Court. This is a major constitutional crisis now in Bosnia, and also a political crisis in this country, where we see the most negative influence of politics on the composition of a constitutional court. The other element, and that's linked to the first one, is the question in how far international judges, international participants can help in such a situation. In Bosnia, we do have 3 international judges to help to come to decisions and to bridge the gaps between the 3 ethnicities. But yet, and understandably, the international element is a difficult one for the country. We see the same now in Ukraine, where they try to rebuild confidence in the judiciary with the help of the international community. So this might be an issue for you to discuss, in how far international influence can be helpful when confidence has been lost in a country. And perhaps the last question, is there a solution one size fits all concerning judicial independence? I think no. I think in this context, traditions are very important. Nevertheless, we can have common standards, but still we have to model each system for each country independently. I thank you very much for your attention, and I wish you an excellent panel and a very, very good exchange. Thank you so much, and bye-bye.
Judicial independence must be protected by constitutional provisions and not only by ordinary legislation, which can be easily changed. The proper constitutional protection should include a number of principles. I'll mention them briefly. The first one, that prohibits ad hoc tribunal. The second principle is that prohibits diverting cases from the regular courts. The third principle requires that cases are assigned by a predetermined plan. The fourth principle is that the judgments have to be enforced and not reversed by other or frustrated by other branches of government. The fifth principle is that there should be a separation between the judiciary and the civil service. The sixth principle is that changes made in the judicial system or in the terms of judicial office will not apply to currently serving judges, but only to future serving judges. The seventh principle is that a number of judges of top courts, such as the constitutional courts or courts of last resort, must be provided in the Constitution in order to prevent court packing by changing the number of the judges. So we come to other aspects that will be discussed by President Milton Ray Guevara from the Dominican Republic, who is also World Law Foundation trustee, and he will discuss how to ensure independence of the constitutional justice, and Justice Carmen Corral that will discuss how to strengthen the judicial independence, a look from the Constitutional Court of Ecuador. She will present her speech in Spanish.
I'll do it in English.
In English? So we made arrangements that someone will summarize it, but now it will be very nice to hear your wisdom directly rather than through a translator. The courts and the judiciary face a great challenge with the introduction of advanced technology in the courts. This includes the rules governing online legal procedures, artificial intelligence in the courts, and measuring courts and judges by statistical studies and personal metrics of judicial performance, which create undue pressure on judicial independence. Professor Sophia Tang of the University of Wuhan in China will discuss the issue of judicial independence and technology. And now it is my honor to invite the distinguished speakers of this session to give their presentations. And I'm honored to invite Professor Pichonnaz to give his statement.
Thank you very much. Thank you very much, Shimon Shetreet, for this very interesting introduction. I'd like also to thank the organizers of thinking to have the ELI, the European Law Institute, for a session, to organize this session around judicial independence. As president of the European Law Institute, let me first say how happy I am that our organizations run this project on European standards of the judicial independence, together with the International Association of Judicial Independence. And let me give you maybe some element of context. The European Law Institute is the so-called alter ego of the American Law Institute. It has been founded in 2011 in Paris, has its seats in Brussels, and its secretariat in Vienna. So it's a truly European organization, an entirely independent European organization which runs projects to provide practical guidance in the field of European law in the broadest sense for legislators in Europe, in the various states, but also for the judiciary and for practitioners. Like the American Law Institute, the ELI prepares principles and model rules where there is a need of harmonization. And therefore, ELI projects are conducted under three main pillars. One is the rule of law and the convergence of legal systems in the 21st century, and today's session is about this pillar, of course. Law and governance for the digital age, and to some extent, of course, what we will discuss here is also covered by this second pillar. And the third one is about sustainable life and society. We have currently 14 projects running together and 11 in the pipeline. And last year, we just completed 5 projects. This just to show that despite our young age, 12 years, we are quite dynamic, if I may say so. What is special with the European Law Institute is that for each project, you do not have only reporters preparing the draft standards or principles, but you have also a team of experts. You have a team of advisors that will interact based on the various drafts. And then you will have also the so-called ELI Council, represented by 56 members elected by all our 1,700 members, who will take position on the drafts and therefore help to improve the quality of the output. And at the same time, as you will maybe hear in the video of Judge Nussberger, what is important, not only in Europe, but also in Europe, is to take into account the cultural specificities, including under the logo of judicial independence. And of course, at the end of all this process, the 1,700 members will vote and will adopt the principles. So it's always under a very large basis. Now, in that context, the ELI has embarked in revisiting the Mount Scopus standards to test them and also to adapt them to the European realities with all the challenges that Professor Shimon Shetreet just mentioned in his introduction. I will not go into all the details of these various principles. Some other speakers, and especially Professor Turenne, will do so, but let me underline that this project is not only timely, it fits also a broader perspective linked to the so-called algorithmic decision-making systems, the so-called ADMS, which will bring some disruptive effects in the field of judicial independence. To be concrete, in 2021, the European Law Institute has produced a set of principles providing for a procedure of impact assessment and authorization for AI systems used in decision-making processes in public administration. The specific procedure of authorization is set in stages and with different input, including input from the public and not only from experts, in order to check and avoid that the recourse to AI produces adverse consequences, especially for fundamental rights. But also to check that the AI will not be biased because of the way the AI has been programmed first and then trained, as we might probably come back with Professor Burhan at the end. When used by judges as an aid to their decision, ADM system also present a potential challenge to the judicial independence. Indeed, even if judges are appointed according to neutral and objective procedures, even if they are fit for their job, if I may say so, and behave independently when taking their decision, where judges use AI system as a help for their decision, they might be influenced in a specific way. AI, of course, does not give the reasoning of the solution that is proposed to assist the judge. It is we know that it's a kind of black box. It gives a result, maybe several results, of course, and such result is led by correlations between facts and a multitude of cases. It is therefore not based on causation principles, on rational analysis, which is at the core of the legal reasoning. This is, of course, a serious concern. Even if you get to similar result, how can you test the quality of the result to which you come? In China, and we will hear more about it later on, lower courts, at least so far as I could see, use AI assistant called Xiaoji 3.0, or sorry for the pronunciation, or Little Wisdom, as I was told it would mean, to assist them in dealing swiftly with numerous cases. Now, so far as I could see, courts have the duty to give an explanation when they depart from the assistant, and therefore they must justify their choices, which seems totally reasonable. But of course, the question is, what if they do not depart from the AI assistant? Do they need to give a reasoning? And of course, if they have to give a reasoning, do they need to redo the work? If that's the case, you would say, why do you need an assistant, right? And the tendency will be, of course, to follow the assistant because it's easier, it goes faster, and also because you do not get noticed if you follow the assistant. In the end, we can see that the judicial independence may be tackled in a more subtle way through AI assistant, because of what we call the cognitive reasons. First of all, the anchoring effect. If you have an assistant that indicates that this is the solution of the case, in most of the cases, it has an anchoring effect so that the judge will be influenced directly and, on this element and might have difficulties to depart from it, even if there are good elements for it. And of course, there are also social pressure to act not only quickly, but maybe not to be always against the virtual assistant, and that might be also a point. So the Eli Monscopus project on independence of the judiciary may not tackle all the aspects of AI, because otherwise the project will never be over. But at least I think that it is also very important to tackle and ensure independence of the judiciary for the more traditional risk, if I may say so, linked to nomination, sanctions, etc., in the field of the judiciary. It is, and it will be, however, more and more central that judges remain also independent in an e-environment when dealing with AI assistant. And here I really look forward to the discussion we might have also after the last presentation. So let me just finish by saying that I truly hope that this wonderful project we will hear about will end. Normally it should end in February 24 with a positive vote by the ELI Council. And for the time being, I thank you for your attention.
Thank you very much, Professor Pichonnaz, for your presentation. And now we come to President Milton Ray Guevara from the Dominican Republic is the President of the Constitutional Court.
Muchas gracias. Permítanme iniciar por lo esencial. La Declaración de los Derechos del Hombre y del Ciudadano de agosto del año de 1789, en su artículo 16 señala: toda sociedad en la cual la garantía de los derechos no esté asegurada, ni la separación de poderes determinada, no tiene, carece de constitución. De manera que en el liberalismo político, la separación de poderes es una de las bases de sustentación de la existencia de una constitución escrita. Y en efecto, la Constitución escrita es un mecanismo de limitación del poder de los gobernantes. La justicia constitucional implica que el poder de aquellos que gobiernan se encuentra limitado por la Constitución, por la norma, sus principios y sus valores, y por ende se han previsto procedimientos y se han creado organismos para dar contenido a esa limitación. El poder a limitar se puede situar fuera del Estado. El maestro Ferraioli lo denomina poderes salvajes. El maestro Mauro Capelletti lo denomina grupos organizados, corporaciones económicas, sindicatos, grupos y entidades profesionales, partidos políticos, entre otros. A eso habría que agregar en ocasiones determinadas las redes sociales, grupos sociales y agencias internacionales. El maestro Capelletti lo considera no menos peligroso y tiránico, no menos inclinado a entrometerse en la vida privada de los individuos y a entorpecer su libertad. Y señala: los fantásticos y maravillosos progresos que se han producido en la tecnología constituyen una amenaza potencial. Los instrumentos que permiten esa injerencia han sido perfeccionados y hacen más fácil ejercer la tiranía. Pensemos en las limitaciones de la inteligencia artificial. Sin embargo, el peligro mayor sigue residiendo en la denominada tendencia tiranía de los poderes organizados de las autoridades públicas del Estado. En la República Dominicana, la Constitución del 26 de enero de 2010 creó, en adición al Poder Legislativo y al Poder Ejecutivo, el Poder Jurisdiccional, pues, bautizado así por nosotros, haciendo uso del concepto acuñado por el profesor Thierry Renaud, el Poder Judicial, pues, está integrado por el Tribunal Constitucional en la cúspide de la pirámide institucional, cuya misión es garantizar la supremacía de la Constitución, la defensa del orden constitucional y la protección de los derechos fundamentales, la Suprema Corte de Justicia y los tribunales ordinarios que solucionan los conflictos entre particulares, entre estos y la administración, y las cuestiones de orden público, y el Tribunal Superior Electoral, que resuelve los conflictos políticos y electorales, en última instancia, salvo en el caso de violación manifiesta de la Constitución. Los dominicanos tenemos una característica: todos los jueces de las distintas jurisdicciones que conforman el Poder Jurisdiccional son jueces constitucionales. El Tribunal Constitucional tiene a su cargo el control concentrado en decisiones que surten efectos erga omne, son definitivas e irrevocables y constituyen precedentes vinculantes para los poderes públicos y todos los órganos del Estado. Excepcionalmente, el Tribunal Constitucional tiene la potestad de decidir sobre el control difuso en virtud de lo establecido en el artículo 53, numeral primero de su ley orgánica. Esto se produce en caso de revisión de decisión jurisdiccional con autoridad de la cosa irrevocablemente juzgada, con posterioridad al 26 de enero de 2010, cuando la decisión declare inaplicable por inconstitucional una ley, decreto, reglamento, resolución u ordenanza. Soy de los que creen que la independencia del juez constitucional estará garantizada por su sometimiento a la Constitución. Ni el Tribunal Constitucional ni ningún juez están por encima de la Constitución. Comparto el criterio del profesor Peter Aberle cuando señala: el juez constitucional está más allá del maniqueo, planteamiento positivista, o la política que transforma el mundo, o el derecho que se abstiene de la política para solo aplicar la norma, sino que se busca a un magistrado constitucional instalado en el medio de la vida social, en el medio del sentimiento constitucional del pueblo y que actúe como representante jurídico de la unidad de la Constitución. La inejecución de las sentencias de la jurisdicción constitucional es un flagrante atentado a su independencia. Las restricciones presupuestarias y las represalias políticas también constituyen atentados a la independencia de los jueces. El Tribunal Constitucional de la República Dominicana representa al Grupo América en la Conferencia Mundial de Tribunales Constitucionales y hemos comprobado las situaciones que estamos describiendo. Las campañas de descrédito realizadas a través de medios por grupos que tienen algún interés, por organismos del Estado o por grupos privados en contra de las decisiones de los tribunales constitucionales, conspiran contra la independencia del juez. Las actividades partidarias encubiertas de jueces lesionan igualmente la misma. La fabricación de expedientes contra jueces por razones político-partidaristas deben ser condenadas. Para este servidor, en el caso del Tribunal Constitucional, el TC ha realizado un ejercicio responsable de independencia jurisdiccional gracias al esfuerzo y sentido de responsabilidad de los jueces que hasta ahora lo han conformado. Si cada juez no es independiente, el tribunal no puede serlo. El Tribunal Constitucional no recibe órdenes ni acepta presiones de los poderes públicos nacionales, ni de organismos internacionales, ni de gobiernos extranjeros. Ha adquirido la madurez para tener una visión de Estado cuando así lo requiere el interés nacional. El Tribunal Constitucional, actuando de esa manera, es la mejor garantía para el pueblo dominicano de que no nos prestemos para el falseamiento del Estado de Derecho, como diría el maestro Alan Brewer Carías, ni para traicionar nuestro juramento de hacer respetar, cumplir y hacer cumplir la Constitución, garantizar su supremacía y proteger los derechos fundamentales. Los 6.180 fallos pronunciados hasta ahora han generado una jurisprudencia en favor de los ciudadanos. Así como no hay primavera sin flores, no hay democracia sin justicia constitucional. Y la independencia de los tribunales, particularmente de los tribunales constitucionales, va a fortalecer el Estado de Derecho tan tan atacado en tiempos presentes por el populismo, por el autoritarismo, bajo esa figura jurídica nueva que se llama el falseamiento del Estado de Derecho, donde hay elecciones pero son trucadas, porque se quita la nacionalidad de algún candidato, porque se le impide a un candidato participar, porque a un partido se le quita el reconocimiento que tiene posibilidades. Formalmente es un proceso electoral, en la práctica es el falseamiento del Estado de Derecho. Yo debo decir finalmente que es justo reconocer que en el caso dominicano los poderes públicos de manera general han sido respetuosos y esperamos que lo sigan siendo de la justicia constitucional sobre una base muy importante. Y ese es un ejemplo que ha dado el pueblo dominicano, la sociedad dominicana y los poderes públicos. En nuestro país todavía existe una cultura del diálogo, donde poderes públicos, sociedad, partidos políticos, grupos sociales, increíblemente para algunos, acertadamente para otros, por un influjo importante de la Iglesia Católica Dominicana y de las iglesias evangélicas, se instauró en la República Dominicana la cultura del diálogo y hoy en día, cada vez que hay un proyecto importante en el país o una situación de interés nacional, el diálogo evita el enfrentamiento estéril. Muchas gracias.
Thank you very much, President Milton Ray, Guevara. And now we are very fortunate that Professor Pichonnaz will give a summary for those who don't know the language of the Spaniards, and therefore our ignorance will be now corrected by Professor Pichonnaz. Please.
Thank you very much. So
You see,
we didn't know that we have someone who speaks both Spanish and English. So just a couple of words, 2 minutes or 1 minute to summarize a couple of points, because President Rey Guevara underlined the importance of the separation of powers in the Dominican Republic under the written constitution, stressing the fact that there are forces, internal forces and external forces that may play a danger, a risk on these constitutional powers, citing a number of authors. He also mentioned the organized group outside of the state, so to say, like syndicates, like political parties, that may, well, on one hand maybe contribute, but on the other hand may also put the constitution of the Dominican Republic under pressure. He mentioned also the necessity to limit these powers, including to limit the powers of the artificial intelligence. And this can be done, he says, only through a constitutional court that should not do politics, but is the last resort to decide between the various conflicts between all these powers, to stick to the constitution as much as needed. And he said, in a way, in the interpretation, the constitutional court should not do politics, but should apply the law, including in a couple of cases in abstract control of the constitution. And then he said there's no democracy without a constitutional court, and this goes also as far as checking not only the formalities, for instance, on elections that may give the impression that there is the rule of law, but when one goes into the detail of the substance, on the way some of the criteria are put in place, it is the opposite of the rule of law. And in that sense, he said, thanks to the Constitutional Court in the Dominican Republic, there's a culture of dialogue between the people, between the various groups and the church, so that there is stability. I hope I did not completely distort your presentation, but that's at least what I understood from it. Thank you very much.
Thank you very much, Professor Pichonnaz, for being not only a speaker but also a translator. As far as I'm concerned, you should get the Medal of Honor that you know, because we were promised that the official languages in this conference are Spanish and English in this order. But I didn't think that there will not be a simultaneous translation. So you have the benefit that you were heard twice, once through your own statement, and then by Moses, who spoke on your behalf. So, since we already smiled 5 times, we are in good shape, right? So now it is my honor to ask President, Vice President, Gonçalo, Almeida, Ribeiro, the Vice President of the Constitutional Court of Portugal, and he will speak on a very important case in the European context, in the European jurisprudence, which is called the Portuguese judge's case. Please.
Thank you. I'm honored to participate in this celebration of the ideal and practice of the rule of law across the globe. I'm grateful to the organizers for inviting me to be here, and in doing so, acknowledging the role of the institution I represent, the Constitutional Court of Portugal, in the affirmation and the development of the rule of law in its jurisdiction. And this year, coincidentally, we celebrate the 40th anniversary of the Constitutional Court, and thereby, to a large extent, the 40th anniversary of constitutional democracy itself in my country. Constitutional democracy being that fragile yet noble alliance between the ideals of popular rule and the rule of law. And I think we should take this occasion to hope that the alliance endures and indeed expands to further parts of the world in spite of the quite alarming threats looming over it. So our chair, as he mentioned, Professor Shimon Shetreet, thought it would be interesting if I shared some thoughts on a judgment of the European Court of Justice of 27 February 2018 that is usually labeled, given its unpronounceable actual name, as the Portuguese judge's case, and I acquiesce to his request without demur. The judgment originated in a preliminary ruling request by the Supreme Administrative Court of Portugal, which means that this Portuguese court posed a question to the European Court of Justice, and that question concerned the temporary reduction in the amount of remuneration paid to the members of the Portuguese Court of Auditors. Now, that reduction did not specifically target these judges. It was part of a general measure aimed at the top holders of political office and the higher echelons of the public sector, as well as their staff. Itself an element of a much broader package of austerity measures undertaken in the wake of the sovereign debt crisis that led the Portuguese government in 2011 to enter into a 3-year bailout agreement with the so-called Troika, comprising the International Monetary Fund, the European Commission, and the European Central Bank, a deal which involved mandatory requirements for reducing the budget deficit. Now, one would reasonably expect the case brought before the European Court of Justice to concern any of a number of possible issues regarding the relationship between the pay reduction and European Union law. Namely, and these are just a few examples, the mandatory or optional nature of the salary reductions in light of the agreement, or the status of this agreement between the Portuguese government and the Troika within EU law itself, or the compatibility of the said agreement with the Charter of Fundamental Rights of the European Union, so on and so forth. These would undoubtedly be issues of European Union law, but these were not the issues at stake in the case. The question posed to the judges in Luxembourg, that's because the European Court of Justice is headquartered in Luxembourg, was whether the reduction in the pay of the members of the judiciary violated the principle of the rule of law and the guarantee of judicial independence and the requirement of effective legal protection and indeed the right to a fair trial. All of these enshrined in a variety of primary European legal instruments. In light of these, it would have been perfectly reasonable and indeed to some extent expected for the European Court of Justice to have ruled a preliminary reference inadmissible on the grounds that it did not concern an issue of European Union law at all. The European standards invoked by the referring court are indeed meant to govern the interpretation and control the validity either of European Union norms themselves or domestic norms adopted insofar as they implement or execute EU law. Yet the salary reduction measures, as the referring court framed them, did not, at least not straightforwardly, fall into any of these categories. They did so indirectly, though, according to the European Court of Justice. The judgment states, and I'm quoting now, Article 19 of the Treaty of the European Union entrusts the responsibility for ensuring judicial review in the EU legal order not only to the Court of Justice, but also to national courts and tribunals. Member states, I'm still quoting, are to provide remedies sufficient to ensure effective judicial protection for individual parties in the fields covered by EU law. It follows, the court argued, that every member state must ensure that the bodies which as courts and tribunals within the meaning of EU law come within its judicial system in the fields covered by that law meet the requirements of effective judicial protection. That was true, the European Court of Justice established, of the Court of Auditors, whose jurisdiction extends to matters involving the use of EU financial resources. Now, for a court or tribunal to provide effective protection, it must obviously be independent. Now, what does that mean? It means, and I'm quoting again from the judgment, that the body concerned exercises its judicial functions wholly autonomously, without being subject to any hierarchical constraint or subordinated to any other body, and without taking orders or instructions from any source whatsoever, and that it is thus protected against external interventions or pressure liable to impair the independent judgment of its members and to influence their decisions. Moreover, the receipt by those members of a level of remuneration commensurate with the importance of the functions they carry out constitutes a guarantee essential to judicial independence, end of quote. This is in line with standard accounts of judicial independence in the scholarly literature and in international reports, which emphasize that one of the external dimensions of judicial independence is the sufficiency, transparency, reliability, and indeed stability of the income earned on the job. Bringing these criteria to bear on the case at hand, the court concluded effortlessly and unsurprisingly that the salary reduction measures at stake in the proceedings did not undermine judicial independence, and it offered two reasons to that effect. First, the measures were general in scope, applying to all top holders of public office and the higher echelons of the public sector, as well as their staff. The judiciary, namely the members of the Court of Auditors, were not specifically targeted. And second, the measures were temporary in nature, lasting only as long as the financial emergency which dictated them, and had indeed been completely reversed by the time the proceedings were initiated. The outcome, we may say, was a foregone conclusion. No one in his or her right mind would think that there really was a serious issue of judicial independence at stake in this case. Now, what makes this case obviously important, and there we go, is not what was decided, but what was established in the process of deciding it, that the independence of domestic courts is an unwavering concern of European Union law, such that all legislation affecting it must be measured against the standards set by the judges in Luxembourg. It is this very doctrine that has enabled the European Commission to sue Poland for enacting legislation that compromises the independence of its judiciary, and has made it possible for judges in member states where the rule of law is at risk to rely on the procedure for preliminary reference to collect the support of their European counterparts. And that is a good part of what makes the Portuguese judge's case, despite the relative insignificance of the matter on which it formally ruled, one of the most important and consequential decisions of the European Court of Justice in the past decade. Yet the judgment, I would say, transcends even that context, for it constitutes, quite apart from the large issues of the rule of law and judicial independence lurking in its background, a striking example of how a court can use a seemingly routine, banal case to permanently expand its reach. A historical parallel suggests itself. Most have forgotten, definitely my students, as I'm a professor of constitutional law as well, what Marbury versus Madison was specifically about. The right of an individual appointed to a minor judicial office by a lame duck president, Adams, to the delivery of the commission which had been withheld from him by the newly sworn-in Secretary of State, James Madison. Even the context of this dispute has faded from memory to a large extent. It was the nasty political rivalry in the early American Republic between two of the most prominent of its statesmen, James Adams on the one hand and Thomas Jefferson on the other, drawing into their personal cockfight the most remarkable among their liegemen, James Madison and John Marshall, who went on to become the Chief Justice of the United States Supreme Court. Now, what everyone knows is what the case stands for in American constitutional law, the proposition that judges have the power to strike down legislation they find unconstitutional. A very banal, indeed dull case that stands for this rather large proposition. Now, the implications of the Portuguese judge's case will perhaps not be as lasting and far-reaching as this, but they will no doubt vastly exceed what it meets the untrained eye. Thank you.
Thank you very much. Thank you very much for agreeing to speak on a subject that is very central to the new legal culture of the European Union, making judicial independence a central basic value under the European Union law. Thank you very much. And now I would like to call upon Justice Carmen Corral Ponce from Ecuador. She is the Vice President of the Constitutional Court, and she will speak on the issue of how to strengthen judicial independence from the perspective of the Constitutional Court of Ecuador. Please speak to the microphone.
Thank you very much, Professor, for chairing this interesting panel. Thank you very much for the organizers for the invitation. It's a very honor for me to share these issues of independence, judicial independence, with all of you guys. I would give a look from the Constitutional Court of Ecuador and all the interesting and worrying things that are happening in my country. The current constitution of the Republic is in effect since October of 2008. It was a result of a constitutional assembly promoted by former President Rafael Correa, who served for 10 years from 2007 to 2017, and is the 20th constitution in our country's history. This constitution is characterized by a hyper-presidentialist regime and its highly regulatory nature. It established the Constitutional Court and granted the mission to defend the Constitution with several attributions and ultimate control power. Currently, the Constitutional Court has approximately 26 competences. The court has 9 magistrates elected by a special constitutional commission responsible for organizing a public competition based on merit and scrutiny. The previous composition of the court before 2019 faced serious concerns about its independence and was even accused of corruption. With the change of government in early 2018, the new president, Lenin Moreno, called for a referendum to lead to the creation of a transitional council of citizen participation and social control, whose mission was to reestablish the country's institutions. acting impartially, this council formed a specialized commission to conduct a public competition, resulting in the selection of 9 magistrates who took office in 2019, and I'm one of the 9. The law stipulates that there must be a partial renewal by thirds, which occurred already in February of 2022, when 3 judges were appointed through a new public competition, while 3 of the judges who took office in 2019 stepped out and they were chosen by a lottery. The 9 magistrates who took office in 2019 committed to a 360-degree turnout in the institutional framework of the Constitutional Court. We established the following pillars as the basis of our work. First one, celerity. The previous court before 2019 left around 10,000 cases unresolved, making it essential to establish a methodology to allow magistrates to address the backlog as quickly as possible. Second pillar, quality judgments. One of the objectives was, and it is, to issue high-quality judgments measured in terms of the reasoning, timelines, and relevance in solving each case. Third pillar is independence. The third pillar is very important, and we committed to maintain a distance, a prudential distance from the powers of the state, and that would allow us to make objective decisions based on the law. The fourth pillar was zero corruption. The court committed to a policy of zero corruption. Various measures have been implemented, such as transparency and automatization of the case assignment process, avoiding any interference or intermediation, as well as to follow a simple rule, which is a chronological order in the decision-making. During the partial renewal of the court in February 2022, the new composition ratified the 4 pillars mentioned above, but added a 5th one, which is the institutionalization of the court. This is due to the importance of strengthening the institution itself, as individuals serving as judges are temporary. This pillar aligns perfectly with the Sustainable Development Goal number 16 of the United Nations, which aims to achieve strong institutions. In light of the aforementioned points, I would like to highlight 5 key factors that have been crucial in the consolidating judicial independence of the Constitutional Court of Ecuador. So that would be number 1, the origin and appointment of judges through a legitimately transparent public competition conducted in an objective and professional manner. The knowledge and preparation of judges, ensuring they meet professional requirements, are independent, have no political commitments, and demonstrate a high moral standard. 3, the commitment to the institution and the country, with the aim of strengthening institutional frameworks and processes to prevent manipulation and prevent corruption. 4, maintaining a distance from the various branches of the government while also maintaining a minimal necessary coordination between institutions. And 5th, resolving cases in accordance with the law, conducting objective deliberations in each case while staying connected to the reality of the country. With this background in mind, I will now discuss briefly with you the recent political events in Ecuador and the role played by the Constitutional Court based on the competences granted to it by the Constitution and by the law. In our Constitution, the National Assembly can initiate a political impeachment against the President of the Republic, as well as his removal when specific conditions are met, either with or without a favorable ruling from the Constitutional Court, depending on the case. On the other hand, the President of the Republic has also the power to dissolve National Assembly under certain circumstances, subject to a favorable ruling from the Constitutional Court or without such ruling in specific cases. In the latter situation, early elections must be called. This constitutional mechanism is known as muerte cruzada or cross death. So actually on March 23 of 2023, the National Assembly of Ecuador requested to the court a political impeachment against the President of the Republic. The court is mandated to issue its resolution within 3 days, requiring a qualified majority of 6 judges. The court issued a majority ruling approving within the time frame provided by the law, with a qualified majority of 6 votes in favor and 3 dissenting votes. As a result, the court decided to partially admit one of the accusations of the political impeachment. This competence and decision made by the court was the first time it was exercised since the enactment of the 2008 Constitution. The political impeachment process began in the National Assembly following the steps set out by the law. However, in May 17 of 2023, the President of the Republic of Ecuador, Guillermo Lasso, who was here this morning, issued Decree number 741, ordering the dissolution of the National Assembly of Ecuador due to a severe political crisis and internal turmoil. Immediately, several demands of unconstitutionality of the decree were filed before the court, which actually were summarily rejected as the Constitution does not grant the court the authority to decide on the validity of the cross-death procedure. During this exceptional regime, and until the installation of the new assembly, the President may, with the prior favorable ruling of the Constitutional Court, issue decree laws related to the economic emergencies which can be approved or repealed by the legislative body that will be elected. The election actually will take place on August 20 of this year. So in this context, in June, the President presented 2 decree laws that already received the court's decision. The first decree law included a series of tax reforms aimed at strengthening the economy of families and popular businesses, and it was approved by the court. However, this was not the case for the second decree law, which regulated the establishment and operation of special zones in economic development and free zone trades. The court unanimously declared this decree law unconstitutional. The court interpreted and exercised its attributions, verifying that there were no evident normative incompatibilities in the content of the decree laws with the Constitution. The court's role is strictly jurisdictional and should not become a political actor or a legislator. However, it did determine that it is competent to qualify the urgency of the decree laws. In conclusion, I want to highlight the difficult and delicate role that the Constitutional Court of Ecuador has had to play for the first time regarding the political impeachment and also the cross-death mechanism. This role has been reflected in its decisions, timely and grounded in the law, ensuring motivation and transparency in judicial independence amid the political events. Ecuador is undoubtedly facing a severe political crisis in which the court has played a vital role. This underscores the importance of judicial independence and reiterates the need for a strong and independent court, which is vital for the defense and the consolidation of democracy. Thank you very much.
Thank you very much, Vice President Corral, on the report about the centrality of the position of the Constitutional Court in Ecuador. And now it is my pleasure to invite Professor Sophie Turenne of the United Kingdom from the University of Cambridge. She is a co-reporter of the ELI Mount Scopus Judicial Independence Project, and we invite you to give the report, please.
Thank you very much. I'm delighted to present the ELI Mount Scopus Draft Standards on Judicial Independence, and in so doing, I speak on behalf of our group of reporters, which includes not only our chair, Professor Shimon Shetreet, but also Professor Frederick Zoll from Poland and Professor Leo Worthen from the US. Now, it is fair to say that it was assumed for a long time that judicial independence in the European Union was uncontested and uncontestable. It is therefore of major concern that the Court of Justice of the European Union has needed several times since 2018 and the Portuguese judges' cases that we just discussed, that the Court has needed to stand up for the values of democracy and the rule of law and to insist on minimal guarantees of judicial independence in the European Union. So in this context, the ELI Mount Scopus standards aims to adjust the international Mount Scopus standards to the situation of European judiciaries, and it aims to promote common standards of judicial independence within the European Union. So I will first briefly present the aims and the scope of these standards, and I will second talk about the central issue of judicial self-regulation, which is perhaps the foremost challenge to address. And I will do that by exploring what judicial self-regulation might mean in three key areas: in relation to judicial appointments, in relation to disciplinary proceedings, and in relation to ethical standards of judicial conduct. So first, then, some quick words about the aims and the scope of these standards. Our standards address four themes relating to the ordinary court, so we're leaving constitutional court aside for the moment. First, the governance of the judiciary, including judicial councils. Second, judicial selection, judicial appointment, judicial promotion. Third, the disciplinary regime applicable to judges. And fourth, the ethical standards of judicial conduct, including judicial freedom of expression, which is a very lively topic at the moment within the European Union, but not only. So these four topics are linked to some general principles dealing with the conceptual imperative requirements of judicial independence, such as, within the context of the European Union, the principle of an effective judicial protection, which was also mentioned earlier. So in writing our standards, we bring together key references to the relevant case law of the European Court of Human Rights and the Court of Justice of the European Union, and putting those two sets of case law together gives a very concrete picture of the problems that our standards are meant to address. It gives a greater degree of specificity to our standards, and this in turn aims to reinforce their practical impact. So moving to the matter of judicial self-regulation, we aim to strongly emphasize minimal interference with judicial work by the executive, but we also aim to ensure that not every matter, including promotion and deployment, is decided by an oligarchy of senior judges at the top of the profession. So within the EU, judicial self-regulation is usually associated with judicial councils. Judicial councils, as we know, have a wide range of powers, including in relation to appointments, and their success varies from state to state, mainly often due to historical reasons. So in this context, what does self-regulation mean for judicial appointments? The issue is best approached, we suggest, by considering how far we need to avoid political influence in judicial appointments, and then how far we need an independent body representing the judges to make the appointments. First, in relation to the involvement of the politicians in the appointment process, our standard number 1 affirms that political considerations cannot prevail over merit. But it doesn't follow, however, that the appointment process must be insulated from politicians. The representative involvement of politicians may, in fact, give greater legitimacy to the appointments. Our position, therefore, occupies the middle ground, with an express emphasis on the need to, quote, safeguard against selection and appointments that would be perceived as biased or directed towards any other improper motive, undermining the independence and impartiality of the judiciary or the quality of justice. Second, on the extent of judicial control over the appointment process, our standard number 4 endorses the common use in European system of some independent advisory body or recommending body to select candidates for appointments. And here we make 2 points. To start with, the membership of that body must be diverse, balanced, and composed in a manner that avoids bias, perception of bias, or any other improper motive. Further, determining membership requires us to focus on the members' ability to identify the most meritorious candidate or the number of most meritorious candidates for the positions concerned. And our explanatory notes then state that membership must include a majority of judicial representatives chosen democratically by other judges. And further, that the political branch should remain in a minority and otherwise cannot have decisive influence if they are represented in the selecting body. We also endorse the participation of legal professionals and lay members in the selection process. This is because the inclusion of lay participants in the selection panel can be seen as a way to open a closed judiciary, a closed judicial system, and therefore it's seen as a way of reinforcing the integrity of the appointment process. Next, we apply the same reasoning to disciplinary proceedings. We emphasize in our explanatory notes the need for the disciplinary body to be separate and independent of the legislative and executive powers. We also suggest that disciplinary bodies must be composed of at least 1/2 of judges, with all members appointed following an independent and impartial procedure. So our standard here to leave open the participation of lay members or practicing lawyers or legal academics in the disciplinary process in order here to prevent the domination of the disciplinary body by one group. While our standards stay silent on who should appoint the members of the disciplinary body, we emphasize the need to select, propose, and appoint members on the basis of transparent and objective criteria and subject to procedural guarantees of impartiality and independence from the executive and the legislature. I'll now come to my third and final illustration. When it comes to ethical standards of judicial conduct, our main point is that, quoting from our standards, judges must lead the adoption, revision, and enforcement of standards of judicial conduct. Ethical standards are not legally binding, and the primary responsibility of deciding a course of action rests with the individual judge. So with this in mind, we list a series of topics on which European judges should take a view for themselves, for example, on the topic of judicial freedom of expression. And our explanatory notes clarify that the initiative to develop and keep ethical standards updated must then be judge-led, whether the initiative comes from judges, judicial associations, or judicial councils. And this, we suggest, is consistent with the principle of judicial independence. So in conclusion, 2 brief remarks. First, judicial independence depends much on the constitutional relations external to the judiciary, such as the relationship between the parliament and the government. But still, articulating more concrete standards of judicial independence will foster an open and transparent discussion on how to reinforce the value of an independent and impartial tribunal within the European Union, as well as how to prevent abuses of power. The second point is that judges have been in desperate need of support in some EU member states. And we intend that the newly drafted Eli Mount Scopus standards on judicial independence will provide specific guidance or indicators to meet minimal standards of compliance. So we need everyone's views and comments to help us giving greater impact to this project. Thank you.
Thank you very much, Professor Turenne, for your report. Now, I would like to invite Professor Giuseppe Ferrari from Italy, Bocconi Milan University. He is a member of the advisory committee of the ELI Mount Scopus Judicial Independence Project. And he will speak on the jurisprudence of top courts, European top courts, and he will also make reference to the ELI Mount Scopus Judicial Independence Project.
Thank you, Shimon. I want to thank, obviously, the LEI and his president, and you as president of our World Peace and Justice Independence Association for the invitation and for this occasion to stay together once again. My focus will be mainly on the disciplinary proceedings because my attention has been triggered recently in Italy by a couple of occasions during which someone has doubted about the real full guarantee of the disciplinary proceeding. Over the last 5 years or so, all over Europe, there have been a number of cases concerning disciplinary action against judges and, to a more limited extent, public prosecutors, mainly in countries where their legal status is more or less the same or equivalent, based on the content of decisions made. This has happened not only in countries that are often labeled as illiberal democracies, but even in countries that are usually considered consolidated democracies, where the relationship between the judiciary and the political powers may be occasionally or cyclically turbulent. It is well known that all over Europe the tradition implies that a judicial office holder cannot be sanctioned in disciplinary terms unless she has not jeopardized the public confidence in the integrity of the individual judge or of the whole judicial order. The standards of conduct which exclude improper or irresponsible behavior must be balanced against the need to preserve full autonomy of judgment. Integrity and independence have to be protected together wherever this is possible. These are the pillars of the regulations applicable, maybe first of all in the United Kingdom, in the United States, and according to the case law of both the European courts, I mean the Strasbourg Court, on the basis of Article 6 of the European Convention of Human Rights and of the European Court of Justice at Luxembourg. The Strasbourg Court has always been consistent in stating that a tenable and credible disciplinary system for the judiciary conditions the reliability of the judiciary itself and the trust of the public opinion towards the judicial system. However, the court has never reached the point that the content of a judicial decision can never amount to a fact relevant from the disciplinary point of view, because there has never been an occasion to reach such a statement. Only in 2021, in the often quoted decision Broda and Bojara versus Poland, the Strasbourg Court has stated that the disciplinary proceedings and the mass dismissals of presidents and vice presidents of Polish courts by the Minister of Justice without proper justification were inconsistent with the principles of independence and separation of powers. It did not had a real need of reaching a statement concerning the very substance, the merit of the problem. However, recently, in a decision dated June 6, 2023, concerning Turkey, the court has stated that a prosecutor, representative of an association of magistrates, cannot be disciplinarily sanctioned due to an interview on matters of public interest. Another recent case concerning Czechia, the Czechian Republic, have saved the disciplinary proceeding applied from the point of view of its fairness, once again from the procedure point of view. To the contrary, the European Court of Justice has examined this topic frontally, again in cases concerning Poland and Hungary, which has been more fully described by Frederick Zoll and Leah Wortham. The very idea of letting disciplinary proceedings be used as an instrument of pressure on judges or prosecutors in order to display influence on the carrying out of their function or of their behavior in general used to be totally extraneous to the case law of the court, but the court came in 2021 to enter this field strongly with the statements concerning the merit of the problem, the impossibility of qualifying the content of a decision as a fact disciplinarily irrelevant. The two events that triggered my attention in Italy are fully described in a paper I am compelled to summarize here for obvious reasons of time. The first one was a case concerning a Russian citizen, son of the governor of Siberia, arrested in Milan in October 2022 on the basis of a warrant following an extradition request by the United States. After being arrested, he was detained in jail. His counsel appealed against this measure and requested house arrest, considering that he owned a house in Milan and that an electronic bracelet could be applied. Meanwhile, also Russia requested his extradition under a somewhat vague allegation of money laundering, to which obviously he did not object. The next day, the Court of Appeal accepted the appeal and he was put in home detention, but the next day he managed to remove the bracelet and escaped. The police officers could only conclude that he had probably fled abroad from some small airport, and the press hinted to the fact that the Russian Secret Service might have been behind his escape. At this point, the Minister of Justice, a retired chief prosecutor, promptly decided to send ministerial inspectors to the Court of Appeal in Milan in order to verify whether the Court of Appeal had taken into consideration all the facts surrounding the extradition procedure. This might result in disciplinary action against the 3 members of the court due to improper activity or judicial misconduct, consisting in the not sufficient consideration of the elements of fact at the basis of the decision. In fact, the investigation could only result in a reprimand or a formal warning, which might somehow adversely affect the careers of the 3 members of the court in terms of future appointments. The disciplinary decision would be taken by the High Court of the Judiciary, which is notoriously very wary of disciplinary sanctions. However, the minister, without any specific complaints, but simply responding to a wave of disconcert in the public opinion, resolved to activate an investigation on the merits of a judicial decision concerning the proper evaluation of all the factual circumstances of the case. The second event is that in May 2021, a cableway in the area of Lake Maggiore collapsed due to the breaking of the area rope and the inefficiency of the brakes, causing the fall of a cable car and the death of 14 people. The local prosecutor, initially entrusted with the investigation, carried out some research and reached a provisional conclusion which included the request of an arrest warrant. The judge of the preliminary investigation totally disregarded these conclusions, denying the warrants and suggesting a quite different investigating technique. The chief prosecutor took the investigation on herself, complaining about the decision taken by the judge of the preliminary investigation, and she asked the High Council of the Judiciary for disciplinary action to be taken against the judge who had in the meantime been set aside by the president of the court. 2 years later, recently, last month, in June 2023, the investigations were closed with the indictment of 7 people, and at the same time, the judge was discharged of all accounts, having acted, so stated the High Council of the Judiciary, according to her personal interpretation of the facts. In this case, it was not the minister to trigger the procedure, but a clash between judicial office holder. This does not imply that Italy is one step away from neglecting the Western legal tradition, or that we are on a slippery slope that leads to a situation comparable to Poland and Hungary. However, there are good reasons to be worried about some signs of difficulty of a fully correct application of the disciplinary principles included in the very idea of judicial independence. The third draft of the LI Mount Scopus European standards is perfectly in line with the indication of the two European courts, mainly standards 1, 3, and 4. However, the real problem in this phase of history of constitutional law, which probably began with the globalization movement after the end of the Cold War, is that many social and political conditions have radically changed, even in countries that we are accustomed to classify as consolidated democracy. New and deeper cleavages have been dividing the very texture of many Western societies. I don't have time to enter into details concerning several traditional democratically consolidated regimes, but the problem is that constitutional provisions that we suggest might be a shelter towards, in order to guarantee fuller protection of judicial independence are probably not enough anymore. They are present in almost all constitutional contexts. Sometimes they are even more emphasized in post-Soviet charters, which were criticized in the 90s of ranks xeros constitutionalismus for having subscribed the whole Western axiological framework out of both genuine enthusiasm for the new condition of freedom, but also of interest towards foreign investments and the adhesion to the European Union or to the NATO. The conclusion that the entrenched shelter of constitutional norms might not be strong enough to prevent gross violations of some principles is hard to swallow for constitutional law scholars. Yet, this stage or phase of contemporary constitutionalism has experienced an almost permanent condition of emergency due to terrorism, financial crisis, pandemic, war. Some scholars speak of emergency constitutionalism or constitutionalism under stress to describe its evolution over the last 25 years. This realistic perspective does not imply giving up the expectations of fulfilling the promises raised by constitutionalism 2.5 centuries ago. However, I believe that we have to keep in mind always that the independence of the judiciary cannot be sustained outside the framework of liberal constitutionalism. It is doomed to live or die together with liberal constitutionalism. We must be strong in the defense of general framework of democracy if we want to really protect judicial independence. Thank you.
Our last speaker, but not the least, Professor Tseng Sophia Tang from China. She is a professor of law, and she is also Associate Dean at Wuhan University and Academy of International Law and Global Governance, and she will speak on judicial independence and technology. Please.
Thank you, Chairman. And I want to thank the audience for still being here. I realize I'm the last speaker and standing between you and the gala dinner, so I will try to be as quickly as I can. I talk about judicial independence and technology. China works really fast in incorporating disruptive technology in the court system. So give me the opportunity to preserve the operation of technology and the role of the judiciary. Some academics argue that technology would promote instead of undermine judicial independence. Because technology is free from the external pressure, technology is immune from corruption. So basically, it can help the judicial independence. But a very close observation realized that technology brings more challenges than the opportunity. So I will talk about 3 issues. The first is the lack of transparency. So AI judge would operate based on 2 factors. The first one is the program, that the second one is the database. So just now we have mentioned that the database may have bias according to the past precedents, but the program also demonstrates people's fault because they are all maintained and designed by the people, by humans. So both of them may have flaws inherently. But judge as a person, they should be able to independently assess all the information and assess the recommendation provided by the AI. Could the judge do that? And the suggestion is it's very difficult. First of all, a lot of AI program is designed by the company. So they are protected as a business secret. And then the judge would have no opportunity to assess the code because they are all protected as a secrecy. Even if judge do not have the expertise to properly assess the functioning of the program. It's very, very difficult. So the serious lack of transparency would undermine judicial independence because judicial independence means judge should be independently to assess all the informations and the recommendations. So they can make independent decision, but it's very difficult for them to do so. So the second challenge is the challenge imposed by the profiling. So a lot of law firms use AI and algorithm to do the judge profiling and predict the result of a case. And they can do the judge shopping. So how can they do that? They just identify abnormality and consider the consistency and the continuity of decisions. And they identify the judges who may be abnormal in their view. And then that will be sent to the public and impose pressure for judges because they are identified as abnormal. So in these circumstances, they are going to encourage popular decisions and then bring great pressure to judges because they sometimes have to make innovative decisions, not decisions based on majority, but those minority decisions. And every cases are different. So this, again, seriously undermines judicial independence. And the third point is the most important point. That is judicial independence is based on separation of power. So the court not only have to trial individual case, they have to also check and balance. So that is what we call institutional judicial independence. But look at the AI system. What happened is normally that is a government project. So government have this project to design a judgment AI and outsource the project to a private company. Therefore, this program, the AI program, will demonstrate not only the public, the political interest of the government, but also it has the financial interest of a company. So in this way, if we ask the judge to rely on the AI recommendation to make decision, what happens is we actually place the government higher than the court, put the court beneath the control of government. And those projects, normally, they can show the public, the political interest of not only the government, sometimes is the leading party. So we basically put judge and the judicial system under the control. And also, this system could identify abnormality. And if a case is identified abnormal, they're going to have people attention. So they need people to review those abnormal judgments. And in this case, that would increase surveillance of judicial system. So this is very serious, and basically we can argue it would institutionally undermine judicial independence. So those are 3 major challenges technology could bring to judicial independence. And finally, conclusion, technology may not promote but undermine judicial independence, so every country should be slowed down before incorporating technology into the judicial system so fast. Some countries may be fast, but the fact is, if you do this further than other countries, the judgment that is based on AI recommendation may be considered lack of judicial independence in the individual case and cannot be recognized and enforced in other countries. Okay, thank you.
Thank you very much, Professor Tang, for being so kind to summarize. Like, you know, there is a, they say radio time, which is long, and there is television time, and you selected the television time. So a short bite. And in conclusion, I decided to give the speakers a very small and symbolic souvenir. And the souvenir is a blessing of the house. And I'll show you how it looks. And it says, home blessing, may this home be a place of happiness and health. May all who live and visit here know only blessing and peace. Let's hope that the blessing of this private home will apply to the universe. And so you probably will not remember what I said, but this will remind you of this event.